Cracking the Code, 3rd edition, Part 1, Section 1, Maintaining Fiscal Integrity, Functional Sovereignty. Maintaining Fiscal Integrity, Functional Sovereignty. Caveat. This treatise constitutes neither the practice of law nor the giving of legal advice and is for informational and educational purposes only. You are responsible for yourself and your own actions. If you act on what you do not understand and cannot support through knowledge and ability, any adverse consequences you may experience are entirely the product of your own doing/omissions. Preamble. For thousands of years, the legal masters of the world have been steadfastly constructing the systems by which world commerce and law now operate. They have developed this system by drawing from and utilizing the timeless principles of human interaction that, over the millennia, have been discovered, distilled, and codified. These fundamentals, common sense principles of commercial law, expressed in the 10 maxims found below, underlie every other form of law in existence. There is no type of legal issue, controversy, dispute, etc., that is not covered, embraced by at least one of these 10 maxims of commercial law. The creators of the system have achieved preeminence by knowing these foundational principles of human interaction and encrypting them into codes for their own aggrandizement, while keeping the uninitiated ignorant of such knowledge and the means for accessing it. The pinnacle of these efforts is the Uniform Commercial Code, the UCC. All of the world commerce now functions under and is thoroughly entrenched in the UCC. However, even though the Uniform Commercial Code has been developed and formulated for accommodating mass exploitation and subjugation, it is but a particular codification of the universal underlying laws of commerce, and most importantly can now be employed for the benefit of the layman now that the code has been substantially, quotes, cracked. The 10 foundational maxims of commerce from which all codes, laws, and statutes are derived and based upon are these. Number 1, a workman is worthy of his hire. Number 2, all are equal under the law, both moral and natural law. Number 3, in commerce, truth is sovereign. Number 4, truth is expressed by means of an affidavit. Number 5, an unrebutted affidavit stands as the truth in commerce. Number 6, an unrebutted affidavit becomes the judgment in commerce. Number 7, a matter must be expressed to be resolved. Number 8, he who leaves the field of battle first loses by default. Number 9, sacrifice is the measure of credibility. If one has neither been damaged nor incurred a risk and is unwilling to swear an affidavit, for example, true, correct, and complete, the commercial equivalent of the truth, the whole truth, and nothing but the truth, on this unlimited commercial liability for the veracity of his statements and the legitimacy of his actions, he has no credibility and therefore no basis of asserting claims, charges, or claiming authority. Number 10, a lien or claim can be satisfied only through rebuttal by counter affidavit, point for point, resolution by jury, or payment. Preface. The legal/contractual status of virtually every man, woman, and child on the planet has become that of a slave, commercial chattel, property, a hopeless indentured servant in perpetuity. In commercial/legal matters, there are only two kinds of people, debtors and creditors. It is an all or nothing affair with no middle ground. If you want the power to exercise your innate sovereignty, you must access the agreed upon rules that provide for your recognition as a sovereign/creditor. the Articles of the UCC. The program outlined herein is a system of simple contractual procedures providing the foundational steps for regaining control of one's commercial/legal/financial future, and brings forth the notion of functional, if not official, sovereignty. Codified law is precise. It revolves on how words are defined. The rules of all forms of law are set forth in writing, words, syntax, grammar, etc. The way words are legally defined is the basis of the game. Words used in commercial legal matters have different meanings than the same words used in everyday parlance. Deadly, destructive violence is attached with the words and the meaning of said words used in all legal documents and proceedings. In commercial legal matters, simply assuming that you know the meaning of a word can cost you dearly. It is vital that you know how the words being used are defined for any hope of knowing what is happening and why. Understand the meaning of the words and you can go forward with confidence and certainty. Remain in the dark about the meanings of key terms and you can lose the entire game in an instant. A glossary of pertinent terms with listings of key definitions, read this process, has been provided. The glossary can save you much time in your quest for understanding, and the value of its annotations cannot be underestimated, because contained therein are insights, cracking the code, are not offered anywhere else. However, it is strongly recommended that you supplement your use of the glossary with one or more of the generally accepted law dictionaries such as Black's, Bouvier's, and Ballantyne's. If you can afford it, get a copy of both the first and most recent editions as well as others if possible. As you will soon learn, no law, code, statute, definition is actually ever repealed. This is an advent peculiar with the UCC. In the case of a controversy between an existing law, code, statute, definition, and one that has been repealed, law, code, statute, definition, controls, see UCC section 1-104. Also, the difference between the first and latest edition reveals how the legal masters of the world attempt to guide the destiny of all by continuously redefining and confusing the meanings of commercial legal terms. In any event, find out the meanings of any term of which you are not certain. Do not take anything for granted. It is also recommended that you obtain a copy of the Uniform Commercial Code issued by your state, since the UCC reigns supreme throughout America and the world. All other codes and bodies of the law are mere subsets of and encompassed by the UCC. See UCC 1-103. And since no part of the Uniform Commercial Code, as well as all other bodies of law considered as supplementing the UCC, is ever repealed, obtaining a copy of the earliest editions available would be a good idea as well. Universal commercial law is the functional common law of the planet and is ingrained in the articles and sections of the Uniform Commercial Code. Interesting. Universal commercial law. Universal commercial law is the functional common law of the planet and is ingrained, so quotes, common law of the planet, and is ingrained in the articles and sections of the Uniform Commercial Code. The entire civilized world, that is to say, the cumulative mass of all governments, banks, courts, tax agencies, and corporations, now runs strictly in accordance with the rules of commerce as set forth in the UCC. Deal with the source, the Uniform Commercial Code. Whereas the first two editions of this manual of necessity, whereas the first two editions parts of this manual of necessity, and because of the state of the art at the time of composition, dealt extensively with tactical measures for surviving the ever-present menace of the United States judicial and tax systems. This volume has rather simplified the entire matter and points the way for a more wholesome, uninterrupted style of living, free of the inherent guile, treachery, and larcenous practices of contemporary legal professionals, taxmen, and government actors by thwarting meritless attacks from such would-be pirates before anything can get rolling. You have been deceived and betrayed and ravaged for your kindness and trust. Really taking advantage of that kindness and trust. However, by merely confronting the exact nature of the con, you can be set free of it. Life no longer need be a dangerous and unpredictable affair. Without taking up historical and legal details at this juncture, which are thoroughly addressed and documented in the supplementing essays and treatises in this manual, which are mandatory reading for a full understanding of what has happened in America, as well as in most other countries of the world, suffice it that you have been swindled out of nothing less valuable than your birthright, your sovereignty, by an insidious lexical artifice. Corruption of your name. An ancient maxim of law states, in order rightly to comprehend a thing, inquire first into the names, for the right knowledge of things depends upon their names. Whereas, quotes, John Henry Doe would signify a true name, written in accordance with the rules of English grammar and the prescriptions of law. All capital letters John Henry Doe, on the other hand, would not. A harmless variant of the original, you might say. A variant of the true name, yes, but the operative term is corruption, and it is anything but harmless. Names of men and women and boys and girls appearing in all capital letters and even abbreviated versions with or without initials, etc., of true names with initial letters only capitalized are corporately colored renditions of a true name and do not identify the being associated therewith. Such names represent property, specifically intellectual property. Through this fact is overlooked by almost everyone in society, but the legal vampires who exist is predicated on its exploitation. New section, corporate names. Checking your driver's license, credit cards, bank statements, IRS correspondence, traffic tickets, etc., you will discover that government agencies, banks, and other corporations, courts, tax agencies deal with you exclusively through various corrupted versions of your true name. And these four types of organizations ruthlessly insist on dealing with you only via all caps, other corruption of your true name in any and all key documents, contracts, accounts, and agreements with them. Their computers are generally formatted for dealing with nothing else. It is interesting that the military, an aspect of government, also designates its personnel exclusively in all capital letters. As you have seen throughout your life, corporations spell their trade name in any format, in any assemblage of letters, set in capitals, in lowercase only, intentionally misspelled with numerals, and even arbitrary non-lingual symbols that they wish. A couple examples: Sunoco, Citibank, U-Haul, U-Haul, Office Depot, Honda, Food for Less, Rite Aid Pharmacy, Kmart, Toys Backwards R Us, Hewlett Packard, 4-Day Tire Stores, Visa, Yamaha, Sears, Compact with a Q, Toys for Tots, State Farm, insurance, Save On, drugs, etc. Construction of these man-made corporate trade names is not restricted by the bounds of English grammar and the prescriptions of law because they are fanciful trade names. That's important. They are not restricted by English grammar and the prescription of law because they are fanciful trade names, one of a kind, objects of intellectual property in themselves, and signify a unique artificial person, a legal entity distinct from all others. Even your personal computer spell checker acknowledges this fact. Type in any random set of upper and lower cases letters on your screen and verify spelling. Then change all letters into capitals and verify spelling again. No error will be indicated. Names constructed outside the bounds of English grammar and the prescriptions of law are corporate/corporately colored trade names. Legally speaking, there is a term that identifies such entities, that is ens legis. Here's ens legis defined below. Original Latin, a creature of law. A creature of law, an artificial being, as contrasted with a natural person. Okay. Applied to corporations considered as deriving their existence entirely from the law. Okay. Black's 4th edition, 1951. A trade name can also be trademarked, service-marked, and copyrighted by the owner for the purpose of restricting others from unauthorized use and unjust enrichment at the expense of the parties that invested in and built up the good name and reputation as goodwill of said trade name in the public mind. Statutory entities must follow statutory law in such matters. Living, breathing, flesh and blood men and women, on the other hand, need only claim or assert their copyright under the common law. Here we go. Common law is defined in Black's 4th. Common law, as distinguished from law created by the enactment of legislatures. The common law comprises the body of those principles and rules of action relating to the government and security of persons and property, which derive their authority solely from the usage and customs of immemorial antiquity, or from the judgments and decrees of the courts, recognizing, affirming, and enforcing such usages and customs, and in this sense, particularly the ancient unwritten law of England. Okay. Here we go. Next subsection. Meet your alter ego. Alter ego, a second self, an inseparable friend. Everything has two inherent aspects: its physical, mental, spiritual manifestation, and the abstract label describing it. Okay? So you got physical, mental, spiritual manifestation, and the abstract label describing it. Okay, so there's those two things. This situation is characterized in semantics as the difference between the territory and the map. That is to say, the thing and its label. So it's like a restaurant's food versus the menu. Whereas water is tangible and can actually be experienced by the senses, the word water is only a symbol, an abstraction of the mind, and cannot be experienced. So, for example, one cannot drink the word water. The mind is capable of imagining unlimited varieties and configurations of abstractions. These include non-tangible concepts and mental constructs such as the people or the nation, corporation, quotes, limited liability, a trust, a government, all entities in legis. So back up here in legis, a creature of the law, an artificial being is contrasted with a natural person. So for example, it's got the two aspects. You've got your ens legis, and then you have your natural person. So you got your in legis corporation strawman name, and then you have your natural person's physical body. Okay, here we go. The mind is capable of imagining, okay, just read that. Other legal terms describing fictitious entities are person and artificial person. Such cannot be seen, nor touched, nor heard. Proper names set in all capital letters, such as the one appearing on your driver license, are trade names and signify artificial persons. Interesting. Your name in all capital letters is no different from that of any other corporate trade name and signifies a legal entity separate and distinct from you, the living, breathing man or woman. Okay, so there's your physical body, and then there's the label that describes that body. And so that all capital letters is just the label of the physical body. The corporate, banking, taxation, legal, and governmental communities collectively, the industrial community, uses this name exclusively when conducting business with you. Via this name, and solely because of this special name, all manner of goods and services are conveyed and transmitted for your benefit by all artificial person entities and legis in the industrial community. Such can interface with your straw man's all caps trade name because all involved, interested parties are artificial persons. Your role as a man or woman in this scheme will be revealed shortly, but at this point in the discussion, you are inextricably linked with your all caps straw man. Okay? Your alter ego strawman is defined as a, quotes, front, a third party put up in name only for the purpose of taking part in a transaction. That is to say, a mere nominal party in a transaction. The legal term describing this entity is straminius homo. Okay, the Latin term defined as follows: a man of straw, one of no substance, put forward as bail or surety. Yeah, so literally, straminius homo, straw man, man of straw. Black's Law Dictionary, 1st edition, 1891, hereafter Black's First. A nominal party straw man can be very useful because its creator can then accomplish things in the name of the straw man that would not otherwise be permitted. That is to say, secretly acquire property, do business with one's enemies, etc. A creator always puts forth a straw man for self-serving purposes and is normally the only one that knows the true nature of the straw man. Outsider parties in a transaction usually believe that the straw man party is the unaffiliated with other parties in the transaction, thereby giving the creator the advantage of the extra man on the field. When your true name, written in accordance with the rules of English grammar and the prescriptions of law, is corrupted into the all capital letters format, a mutant straw man is created. Okay, so there's physical body you, and then there's label you, which is the straw man. The new all caps name is a legal entity, corporate or corporately colored, distinct from you, and is the only type of person, quotes person, with whom government, courts, taxmen, banks, and corporations will, in fact, can do business. So when you want to do business, you have to do it through that straw man. If you do not believe this, just examine the documents you received from these types of organizations, that is to say, Social Security cards, court records, credit cards, tax bills, permits, driver license, passport, bank statements, etc. All name entries are set in capitals exclusively, with the occasional exception of upper and lowercase abbreviations, so such as initials, etc. And then usually only in correspondence. When some government or corporate entity is coming after you for payment, you will never see your true name listed as the account holder. That is, the initial letters only capitalized. In the caption of their legal briefs, only the trade name of your straw man. Why? This is the only way they can do business. And that is exactly and only what it is, business. Many grammar books and legal publications identify permissible methods for displaying proper nouns or names, one of which is the U.S. Government Style Manual, a manual of style from year 2000. Chapter 17, Court Work, spells out with examples acceptable ways for presenting names, 52 variations in all, and never once recommends an all caps name format in court paperwork. Despite the conspicuous absence of such mandate, the caption of every single federal and state, county, and city court brief, without exceptions, contains name of plaintiff and defendant, petitioner, and respondent, etc., in all capital letters format exclusively. Since there is no legal authority requiring that proper nouns names be set in capital letters, why is this practice permitted, indeed enforced, excluding all others? Interesting. Chapter 17, Court Work, says, with a few examples, acceptable ways for presenting names. So there's 52 variations. But of the 52 variations, there is no all caps name ever mentioned, or never once recommends an all caps name format in court paperwork. Interesting. The people of the world have been politically and financially ravaged because they do not know of their alter ego, public persona straw man. Bankrupt governments covertly create and use such straw man or trade names actually for the purpose of doing business with said trade names without ever openly disclosing the practice, and siphoning wealth from otherwise sovereign men and women and conveying such proceeds into the coffers of their creditors, the masters of the Federal Reserve and International Monetary Fund Syndicate. After redemption, that is to say, after redeeming or reclaiming your intellectual property, all caps straw man trade name, you can use the straw man for your own benefit rather than endure its continued economic exploitation and the concomitant. The heck does that mean? Concomitant? Existing or occurring together, attendant, okay? Economic subjugation associated therewith. All right, next subsection, analyzing the obvious. A landmark Supreme Court case in 1795, Penhallow versus Doane Administrators, 3 U.S. 54, number 1, LED 57-3, Dallas 54. Defines government succinctly. Governments are corporations. Inasmuch as every government is an artificial person, an abstract, and a creature of the mind only, a government can interface only with other artificial persons, Okay, so for example, okay, so here we go. The imaginary, having neither actual, the imaginary. So basically, what I'm seeing in my mind is I'm projecting this image in my head, and it's a straw man, and that straw man does business with the imaginary, in their mind, government. Okay, maybe that's how it is. Let's see. The imaginary. Okay, so governments are corporations, mind only. A government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. Okay. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., thereof, can concern itself with anything other than corporate, artificial persons and the contracts between them. Okay. One might immediately dispute this statement by pointing out that the people are acted upon by agents of government and are regulated, fined, imprisoned, plundered, brutalized, and killed by government officials every day. True, but let us step back from the fray and take in the whole macrocosm that we call modern civilization. It is fairly obvious that a thing created can neither be greater than the creator that brought it into existence. Please follow along with this syllogism. Let's see, a syllogism is a logical scheme of formal argument consisting of a major and minor premise and a conclusion, which must logically be true if the premises are true. Okay, so let's follow the syllogism here. Number 1, God created man and rules over man. Therefore, man can never be greater than and can never rule over God. Okay. Number 2, man created government, an artificial entity, as a service, facility, or slave. Therefore, government can never be greater than and can never rule over man. Number 3, government then created corporations and corporately colored entities, also artificial persons, slaves, for the purpose of ruling over them and collecting revenue. Therefore, a corporation, corporately colored entity, can never be greater than and can never rule over the government that brought it into existence. Number 4, therefore, a corporation, corporately colored entity, can never be greater than or rule over government, can never be greater than or rule over man, can never be greater than or rule over God. Interesting. So the creators can never be ruled over the thing that was created. So the created cannot rule over the creator. Despite the logic of this example and is pointed out above, anyone can look around and see that the above hierarchy of rule is certainly not the case in America today, and likewise almost everywhere else. Yeah. A simple observation tells us that government rules over people, not the reverse. What is missing from the foregoing equation is the same thing that is missing in your awareness about your life, the existence of your strawman trade name, plus your obligations coupled therewith. In the above example, you, the man or woman, are described in categories 1 and 2. So categories 1 and 2, God created you, and you created government, which is an artificial entity. Your all caps and Legis strawman falls into category 3. So category 3, government created your strawman. But until now, You are not even aware of its existence at any level. For purposes of ruling over flesh and blood people, such had to be somehow corralled into the artificial sphere. So, the only realm that government, being the slave of the sovereign man, because we created government, and so being the slave of the sovereign man and woman that created it, can dictate over. So they bring us under government by a sly thing of making us appear to be the same as our natural bodies, the same as our trade names. Government, number one, corrupted. Okay, for purposes of ruling over flesh and blood people, such had to be somehow corralled into the artificial sphere. The only realm that government, being the slave of the sovereign man and woman that created it, can dictate over. Here's the two-part governmental artifice that facilitated this transformation. Okay, government does two things. Number one, corrupted the true names of sovereign men and women into corporately colored, quotes, mirror image, all capital letters, trade name at the time of falsely required registration of the biological property via the birth certificate, and omitted informing people of the creation of the new created creature, ens legis. So ens legis is your trade name, corporate franchise, citizen of the United States, trade name. And then number two, deceived the flesh and blood men and women of the sovereign constituency into unwittingly, voluntarily contracting as surety. That's an important word for later. For the trade name, concealing from the victims their new status, but also heartlessly enforcing the new obligations without benefit of explanation. So let's look at, what is a surety? Okay, here we go. We're going to get into it. Okay, surety, there it is. Surety, a person who is primarily liable for the payment of another's debt or the performance of another's obligation. So they contract with your artificial person, and they want you to be the surety and be liable and accountable, or maybe not accountable, but liable for the payment that the straw man gets into and all that trouble. So, the device and practice under number one above, committed via an official authorized subterfuge known as a legal fiction, opens the door so government actors can literally pretend a false reality into existence and then act on it without any obligation of notifying anyone about it. Now, under number two, actors in the government have secretly created contracts of suretyship, but without informing prospective sureties, thereby establishing an ongoing Machiavellian scheme whereby a sovereign man or woman can be treated as the equivalent of his or her inert, inanimate, artificial, paper and ink, corporately colored counterpart strawman, once the mark intended victim in a confidence game has been suckered into the contract. Okay. Suretyship. Suretyship is defined as the legal relation that arises when one party assumes liability for a debt, default, or other failing of a second party, and the liability of both parties begins simultaneously. In other words, under a contract of suretyship, a surety becomes a party to the principal obligation. That's from Black's Law, 7th edition. Suretyship is further clarified as follows from Bouvier's 6th edition. The contract of suretyship may be entered into by all persons who are sui juris. Let's look up sui juris real quick. Nope. Look up. And, okay, so the contract of suretyship may be entered into by all persons who are sui juris and capable of entering into other contracts. Sui juris, Latin, of his own right, possessing full social and civil right, not under any legal disability, or the power of another, or guardianship. A surety is equally liable for the obligations of the principal he is bonded with. Okay, so stocks and bonds. A surety is equally liable for the obligation of the principal he is bonded with. However, as you can see in Bouvier's definition above, only a sui juris man or woman is capable of becoming a surety. Okay, examining the definition of sui juris more closely, you can discover that this is an artfully watered-down camouflage term for the legal equivalent of a sovereign, of his own right, not under the power of another. Suretyship. What this means is that in the eyes of the law, only a sui juris, sovereign, self-governing, responsible man or woman possesses and can exercise full right and power and is legally qualified and eligible for being hoodwinked, conned, deceived, bamboozled, swindled, shafted, cheated, hornswoggled, defrauded, scammed, duped, tricked, trapped, and suckered into becoming a surety for his or her tangible, artificial, mirror image, paper and ink, straw man trade name. Hence, the following inescapable conclusion: were you not such a sovereign, self-governing, sui juris, responsible party in the first place, you could never have become a surety for anyone or anything else, and the straw man, any time thereafter. Thus, we have uncovered the answer for the apparent conundrum cited above, revisiting government ruling over man. A sovereign man or woman has the sovereign right and power for contracting away his or her sovereign rights and power if he or she in his sovereign capacity so chooses, otherwise legally known as the unconscionable bargain, or that is to say, a contract which no man in his senses, not under delusion, would make on the one hand, and which no fair and honest man would accept on the other. Unconscionable bargain. But business as usual for the legal masters of the world. Your self-appointed rulers need only the minutest or smallest justification for inflicting the full fury of their wrath upon you. Until recently, all such contracts were secret, invisible, and unknown for everyone but the man-haters that devise them and the hellhounds that enforce them. In your particular circumstance, the artificial, all-caps straw man is the principal, and you, the living, breathing flesh and blood, man or woman, the unwitting surety. Next section. The underlying con beneath the con. Likely, you are following this essay and have a good grasp of the concepts set forth so far and are interested in carrying forward and gaining more understanding about how these things apply in your life and what you can do about it. But let us not digress for a moment. A great number of Americans have figured out that the all-caps corruption of their true name is somehow being used against them, and we shall thoroughly address that issue momentarily. However, there is an even subtler con underway concerning the name, and it has been so well designed and orchestrated that almost no one has ever conceived of the possibility of its existence. Although knowledge of this particular stratagem is not necessary for application of the practical remedies contained herein, there is no surety in existence that cannot benefit one or benefit from its revelation, no matter the degree of understanding. It reflects the very essence, basis, and nature of your position in American society. Let us take two entities, one actual man and woman known as the king or queen of the state of Great Britain, and an artificial, the state of United States. Let's look at that real quick. United States, a singular proper noun, and represents a city-state domiciled in Washington, D.C. Okay, so that's just 10 square miles. You'll see that on Google Earth. Okay, the artificial state of United States, a sub-jurisdiction under a aegis of the crown in front for the legal masters of the world, and examine a peculiar right claimed by each. The sovereign in Great Britain must consent before he or she can be sued in the royal courts. United States, the proclaimed sovereign on this side of the Atlantic, must also consent before it can become the subject of a lawsuit in its own courts. Okay, here we go. Bouvier's eighth says this, the sovereign. Okay, from the definition of sovereign in Bouvier's 8th edition, the sovereign, whether the term be used with respect to the state or to the chief ruler of one, is accorded an immunity from suit in courts of justice. This doctrine obtains both in England and in this country. It is a general rule.